This is John Burke, visiting lecturer at Wasaba University. Tonight I will talk again about arbitration. So in yesterday's video I explained that the basic foundation of arbitration is the contractual agreement between the parties to arbitrate the dispute. This contract is called "it ousts the jurisdiction of domestic courts." So this is an important concept to remember when you're dealing with arbitration clauses in terms of the contractual obligation. What I want to do tonight is I want you to navigate to the SIAC, which is the Singapore International Arbitration Center, and you can simply navigate to their page, siac.org.sg. And when you open this page, what I want you to do is go to the menu list with the heading Arbitration and scroll down to Model Clauses and open up the SIAC Model Clause. So this is an example of a model clause that you would find in a contract that wants to stipulate that the arbitration will be held under the auspices of the Singapore Arbitration Center. But as I said, there are many arbitration centers, and I don't want you to get caught up in Singapore. It just happens to be that Singapore is a great arbitration center and has very well-designed model clauses. So if you look at the SIAC Model Clause revised in 2024, you can see the simplicity of the language. And most arbitral centers will use a clause with virtually similar language. So what does it say? Any dispute arising out of or in connection with this contract, including any question regarding its existence, validity, or termination, shall be referred to and finally resolved by arbitration administered by the Singapore International Arbitration Center in accordance with the arbitration rules of the Singapore International Arbitration Center for the time being in force, which rules are deemed to be incorporated by reference in this clause. All right, this is just a fancy way of saying that two parties agree to resolve any dispute by arbitration using the Singapore International Arbitration Center as the administrative organization, and they're binding themselves to arbitration with language such as any dispute arising under the contract shall be referred to and finally resolved by arbitration. So these are important words. These are key words. But this one single clause is the only thing you need to establish that two parties want to resolve the disputes by arbitration, not by domestic courts, and not by any other method of dispute resolution, such as mediation. Now, if you read further, it says the seat of arbitration shall be Singapore. Now, this is language incorporating a legal nuance. The seat of arbitration means that the legal place of arbitration is going to be Singapore. So what significance does this have? Well, the significance that it has is that you are saying that the law governing arbitration will be the national law of Singapore. That doesn't mean that's going to be the law governing the substance of your contract or the law governing any other matter. It just means that the national law of Singapore will be the law that is governing your arbitration procedure. And it has one important consequence, and that is if the parties need the assistance of a judicial court, they will seek the assistance of a judicial court under the national law of Singapore. So that law will tell you which court to go to in the event that you need court assistance or you want a court to review some sort of interim decision taken by the tribunal. So you use the courts of Singapore. So that's the legal significance and even the practical consequence of saying that the seat is in Singapore. Then you can specify the number of arbitrators. Generally, it's one arbitrator or three arbitrators. Then you can you can select your language. So most of the times it'll be English or a language that is common to the parties. Now it also says the law governing this arbitration agreement shall be whatever. It doesn't have to be the national law of Singapore. This is to be distinguished from the seat or legal place where the arbitration is said to be taking place. Even though the arbitration may not physically take place in Singapore, nevertheless we have this fiction that the arbitration, for purposes of legal context, is taking place in Singapore. Now, the law governing this arbitration agreement, I would say, if you're going to use Singapore, stick with Singapore. Don't make it complicated. Don't all of a sudden say the law governing this arbitration agreement shall be the law of Germany or something like this. It's going to really mess things up. So you can see that in brackets here, for example. In respect of any court proceedings in Singapore commenced under the International Arbitration Act of 1994, the parties agreed to commence such proceedings before the Singapore International Commercial Court. So that's the significance of the seat. Now you could see the applicable law, but that would be the applicable law as to the contract itself. And it can be whatever you want it to be. But you should be clear. Don't say something like the law of the United States. What would this mean? Generally, contracts in the United States are not governed by federal law, not at all. It's individual states. The same would be true. This contract is governed by the laws of the European Union, and that would make no sense. You would have to pick the law of a particular member state. And sometimes when you pick the law of a member state, you have to remember that the parties may be resident in states that have a treaty between them, like the SIAC, which is the Convention for the International Sale of Goods. So you want to make sure that you understand the significance of your choice of law provision, which is what this is. So I think that I don't want to go any farther tonight, because this SIAC Model Clause, and it looks like many other model clauses used by arbitral centers, but it's very good. Why do I say this? One, we get the single paragraph, which is sufficient to enter into a binding arbitration agreement. We also identify the legal place where the arbitration is taking place. We identify the number of arbitrators who want. We determine the language. We determine the law governing the arbitration agreement, which can be different from the law governing the contract. And then we have our choice of law clause, which is the law that is governing the underlying the law that is going to govern the underlying transaction, whether that be a contract for the sale of goods, a contract for services, a licensing agreement, a construction contract. It can vary depending upon whatever transaction you're referring to. So my recommendation is to take a look at this clause, and if you decide as a manager of a business that you prefer arbitration rather than litigation, particularly in the context of an international commercial transaction, you're going to use language typified by the SIAC Model Clause. I'm going to end there for tonight. Again, you have my email address, and I hope to see you shortly to continue with my next video. Goodbye.